cover the things that I could cover in this short span of time. I hope I'll do my best. Okay, so let us move forward with whatever that we are going to see today. So the first of all, when we think about ADR, what do we think about? Firstly, what comes to our mind? Uh, Anyone, like, if anyone wants to add something, like, what do we think about?
Dispute resolution.
Yes, it is disputes resolution, right? But when we think about ADR, the first thing what comes to my mind is in our country's context is the Arbitration and Conciliation Act of 1996, right? So basically, it's the first word, that is arbitration. It clicks quickly that okay, ADR means arbitration. Somewhat like generally people tend to look ADR in terms of arbitration and mediation, right? These are two of the most prominent forms of alternative disputes resolution. So first of all, therefore, we should be focusing on what exactly the arbitration is, because when you'll read about the ADR, if you'll go through the books and the text that is available online, you'll realize that 90% of the material that is there on the subject of ADR is some way or the other related to the arbitration only, because it is a very uh, substantial portion of this practice. Because if you'll see that the big corporates or the uh, the sectors wherein there is a bit of technicality in the issues that arise in between the parties, they tend to prefer to go for the arbitration, right? And there's a reason to it. Why do they tend to prefer to go for arbitration? We'll be looking at that as we move forward with our discussion. So basically, what arbitration is basically uh, this might sound a bit weird, but you can say that parties appoint their own court, right? Because if you'll go to a court for your dispute resolution, what will happen is that you'll be getting dates after dates, especially in civil disputes, like the disputes of money recovery, the injunctions, the stays. In those cases, it is a very tiresome process. I'm sure, like, some of you might have visited the courts and might have seen the environment there, and how the work is done there, right? So for that reason, the people who can afford, right? Because if you'll see the arbitration, if you'll see the clients that are there in the arbitration practice are the corporates or the uh, big institutions who can afford these facilities. So basically, arbitration is a luxury that is given to that a few can afford in order to get their disputes resolved in a quick and efficient manner, right? Because for them, time is more precious than whatever the cost of the whole arbitration could be, right? So basically, arbitration is a private and binding method of resolving disputes where an impartial third party, that is an arbitrator, hears the case and makes a decision on that. Okay, so arbitration, as you might be knowing, that there are specialized centers for arbitration in some places, but what the essence of arbitration is that it is a party centric process. Okay, so if there is no consent of the party, nobody can force you to get into the arbitration. Okay, and parties have autonomy with regards to a lot of things. Let's say, for example, with regards to choosing the venue, the place, or the language or the procedure, the parties have a lot of autonomy. So you'll see that for example, last few arbitrations that I've attended or I've worked upon, they were conducted at some of the hotels, at some of the offices of advocates or the judges. So these are the kind of places where the arbitration tend to happen. Okay, so from this, what you can understand is that it is a very private and confidential process of getting your disputes resolved, wherein you do not have to uh, spill your beans in public for everyone to see whatever that your disputes are. Okay, so it is alternative to a court litigation, which emphasizes efficiency and confidentiality with along with the flexibility. Okay, so this is somewhat arbitration is all about. Apart from that, there are certain things that can be arbitrated and there are certain things that cannot be arbitrated, which law prohibits. So if you'll see a lot of disputes like the commercial disputes, international disputes, basically the disputes that are a bit technical in nature, which the courts might take a lot of time to address and to resolve. Okay, in those cases we tend to prefer to go to arbitration, but there are certain cases like the criminal offenses or the matrimonial cases, they are generally not, or they are not subject to arbitration. All right, so there are certain disputes that can be arbitrated and there are certain disputes that cannot be arbitrated. Okay, so this is what the basic introduction with regards to the arbitration is all about. If anyone wants to add something and if anyone wants to ask something, please feel free to unmute yourself to say whatever that might come to your mind while we are discussing anything. Okay, if there's anything, please let me know, or then we'll be moving forward with our further discussion. If there's anything, do let me know about it. Okay, so as we've just begun, I think there's nothing as such that anyone wants to ask. And okay, let me tell you that there's no restriction as to when you can unmute or when you can speak. You can speak whenever you want to, you can ask whenever you want to, right? So moving forward, we must understand what are the key features of arbitration. Okay, so arbitration is basically a party-centric process, right? But it can be voluntary or it can be mandatory arbitration, right? So we'll understand the context in which these words are used. Okay, so in voluntary arbitration, the parties willingly agree to arbitrate, often through an arbitration clause in the contract or a post-dispute agreement, which reflects a mutual consent and flexibility. So basically, what the voluntary arbitration is that both the parties are agreeing on the fact that okay, if there's any dispute that might arise in between us in future, we might be referring to arbitration for those disputes. So this is a voluntary arbitration. Apart from that, there's this mandatory arbitration wherein it is required by law according to the contractual terms, leaving parties no choice but to arbitrate, because the contract is framed in such a way that okay, you might have seen these terms in some of the contracts that if there is any dispute with regards to this and this or so and so thing, the parties shall be resolving those disputes by the way of arbitration. So this is an example of mandatory arbitration wherein one of the parties can send you notice, and if not, they can apply to the court for referring parties to the arbitration. We'll be looking into the intricacies of that as we move forward with our discussion, that how the court refers, how the court appoints the arbitrator. So mandatory arbitration is where the court gets involved. Okay, and these are common with regards to the employment contracts and consumer agreements, etc. So all in all, what we can understand is that arbitration has to be agreed upon by the parties, because if there's a contract, there has to be the agreement by the other party as well, right? Because they might be knowing that okay, if there's any dispute, it might go to the arbitration. So it is one way or the other, it is a voluntary process which the parties opt that okay, we want to get our dispute resolved through the arbitration, right? So these were some of the key features of the arbitration. So moving forward, we will be looking at what are the arbitration agreement. So basically, arbitration agreement, what you can understand, that it can be a clause within the agreement that, okay, there were like 10 to 11 clause, and the 12th clause was that if there's any dispute, the parties might refer to the arbitration. So it can be in that form as well, or the parties can opt to have a separate arbitration agreement after the dispute arises, or along with the main substantive agreement, they can have a separate agreement with regards to the arbitration. So this can be a form of arbitration agreement, and it is required under under most of the laws. And since we follow the unilateral model law, it is also mentioned in that model law, and we have the definition of arbitration agreement, if I'm not wrong, in the section 7 of the Arbitration and Conciliation Act. Yes, it's the section 7. So we have the definition of arbitration agreement in the section 7 of the Arbitration and Conciliation Act. And basically sometimes what happens, the arbitration agreement itself gets challenged. So you just keep this thing in mind, that the courts or the tribunal as well can decide on the validity of the arbitration agreement, but all that depends at the stage at which the proceedings are at right now. So there are certain things which can be asked before the formation of an arbitration tribunal. So before the arbitration tribunal is actually formed, you may approach to the court for certain reliefs or certain issues. So in that way, the arbitration agreement can also be challenged, right? Moving forward, we must understand, okay, there's an arbitration agreement, but there has to be an arbitrator, right? Because it's not always very easy to get an arbitrator appointed, because there might always be some issues with regards to the fact that who shall be an arbitrator, because it's very rare that if there's an agreement with regards to the fact that there shall be a sole arbitrator, it's very rare that parties mutually agree in the first place that, okay, this person shall be an arbitrator, because there's always an issue of impartiality, or being connected to someone or something like that. So basically, whenever an arbitrator is appointed, it's under the section 12 that he has to disclose everything with regards to whatever his relationship with any of the parties is there, right? But apart from that, it's rare that parties agree on a sole arbitrator. Therefore, there is section 11 of Arbitration and Conciliation Act, wherein there's a process how the arbitrators are appointed, right? So if you'll see section 11, the parties are free to decide on the number and the nationality of arbitrators. So but the only thing is that the numbers of arbitrators shall always be odd, right? So there can be a sole arbitrator, and if the parties fail to agree on a sole arbitrator, the High Court, if it is a domestic arbitration, the High Court can appoint the sole arbitrator, and if it is a international commercial arbitration, the Supreme Court appoints. So that is how the High Court appoints. And apart from that, if parties fail to agree with regards to the third arbitrator, what generally happens is that each party chooses one of their arbitrators, and those two arbitrators, they in turn select the third arbitrator who presides over the arbitration proceedings. Okay, so this is how the process is given in the section 11 of Arbitration and Conciliation Act, wherein the appointment of arbitrators are given. So if you'll recall whatever that we have covered till now, we have understood what are the what exactly is the arbitration, how the arbitration process works, and what all disputes are arbitrable. After that, we've looked into the key features of arbitration as to its voluntary and mandatory nature. After that, we've looked into what exactly arbitration agreement is, understanding the fact that it can be in the form of a clause in the agreement, or it can be a separate agreement, or how it can be challenged. And after that, we've seen, okay, till the arbitration agreement is there, we've seen what exactly is arbitration agreement. And after that, we just saw that, okay, now that we have realized that there is an arbitration agreement, how the arbitrator is appointed, and what is the manner of appointing the arbitrator. So you just have to remember that for the appointment of arbitrator, it's the parties who have to approach the high court for the appointment of arbitrator if they cannot agree on the sole arbitrator, right? So this is given under the section 11 of the Arbitration Conciliation Act. So till now, if anyone wants to ask anything, and if anyone has any queries, or if anyone wants to add up to the discussion that we've had till now, please feel free to add up whatever that is there in your mind, right? uh, or else we shall be moving forward with our discussion. If there's anything, guys, please, because I want this to be a discussion sort of thing, because it's not it shall not be a one-way process, right? So if anyone has to add anything to our discussion, please feel free to
Excuse me, sir.
Yes.
So what is the difference between arbitration and conciliation?
Okay. So basically, Mannat, right? So basically, arbitration is a process wherein it's more like a courtroom process. बस फर्क इतना है that here you appoint the judge. Understand? Because arbitrator passes an award and it is binding on the parties. It's win or lose situation. One party wins, one party loses. Yes, they try to make a balance in between the interest of the parties, but there's always a winner or a loser party. So it is that sort of process, arbitration. But in conciliation, what happens is that the conciliator tries to make parties to reach a settlement. Okay, and after that settlement is reached, it after it is written down on a paper, it has the effect of being an arbitration award. Okay, understand that the settlement agreement is reached in between the parties according to section 56 of the Arbitration Act, and after that it becomes, or it gets the authority of being an arbitral award. But arbitration from the day one is a process wherein that, okay, one party is going to lose and one party is going to get something or get the relief. So that is the basic difference between the arbitration and conciliation. That the focus of conciliation is that the parties tend to reach to a settlement in between them, in between them, because you can understand this fact from the fact that in arbitration there can be odd number of arbitrators, right? There has to be odd number of arbitrators. Let's say, for example, there can be a sole arbitrator, or there has to be 3 arbitrators, but there cannot be 2 arbitrators, right? Because then there might be conflict of opinion in between the arbitrators, and they could not reach a judgment wherein they can decide that, okay, this is how the dispute is to be resolved. So basically they are focusing on resolving the dispute. But on the other hand, if you look at the conciliation, there can be even number of conciliators, because their job is not to decide anything. Their job is to find a way through. And in the process of conciliation, you'll see that the conciliator actually actively suggests that, okay, this can be a point of settlement in between the parties, but you'll not see the arbitrator suggesting anything, right? In conciliation, the conciliator facilitates you to get into a settlement, and he actively participates and advises you that, okay, this can be a point of settlement. But it is not so in the arbitration. Here, like a judge, the arbitrator will uh, try to resolve the dispute, but the focus is not the settlement, right? Okay, I hope I've answered your query, Anat.
So basically, arbitration is like the traditional courts, and conciliation. In conciliation, both the parties are at a win-win situation, right?
Yes. More like that, because just the difference between an arbitration and a traditional court is that the arbitration is not bound by the rules of CPC. Okay, they are required for the purpose of enforcement of award, and after that, but that is after the arbitration process is over. But yes, you can say that arbitration is more like a courtroom process. It is more binding in nature upon the parties, and the conciliation, on the other hand, is more settlement focused process. Yes.
And is the decision made by the conciliators is binding upon the parties?
Only if the parties agree. So basically what happens, consider this example: there are two parties in arbitration. Both of them presented their claims, statement of claims, and respondent's written statement, all of those things. And after that, looking at both the things, the arbitrator decides and gives an award, and that is binding on the parties, whether they agree with it or not. Because आपको award ठीक लगे या ना लगे, you'll have to follow whatever the arbitrator has given in his award. You can challenge it later on. You can file an application for setting it aside under section 34 of the arbitration act. So you will have to follow that. But in conciliation, what happens is that, okay, conciliator has suggested something to, let's say for example, I'm a conciliator, and I have suggested to a party that, okay sir, see that this can be a point of settlement in between you and the other party, but it cannot be binding on the parties until unless both the parties agree and they sign on it. It is basically a written settlement. So jab tak parties sign na kare, it cannot be binding on the parties. Okay, so understand the difference. The arbitration award is always binding on the parties, whether they agree with it or not. But conciliation ka settlement is binding on the parties only after they sign on the settlement agreement, right? So conciliation is more of a voluntary process, right?
Yes,
I
sir.
hope I've answered it. Okay, thank you. So, with that, we shall be moving forward to understand
Hello.
that. Yes, please.
Hi, Arpit. Karthik this side.
Hello, hi, Karthik.
Basically, it's not a question that I want to ask. I want a viewpoint on this topic that don't you feel this arbitration, that is ADR process that has came diving into this society very fastly right now,
Hmm.
is a court's phenomena to get away with their duties? Are they backing up with this scenario of formalization of disputes?
Mm, sorry, as far as I could understand, that you're saying that we can see the arbitration as the courts escape from their responsibility of getting disputes resolved
Yeah.
on a timely manner, right? Okay, so there can be multiple perspectives to one thing, right? So we can view it from that perspective as well. But what we can understand is that more than a escape from the court's responsibility, it is uh, a mechanism that facilitates the people who can afford to have speedy justice. Because in India, the justice is not free until unless it is there's a criminal offense or there's an offense that affects the society. Because if you'll file a civil suit, you'll anyway have to pay the court fee and you'll have to bear the court's expenses, right? So justice in civil matters is never free. So you can say that the disputes have been graded in categories. So if there's a dispute for which you know that there's no point of taking up the arbitration because the dispute is not as such. Let's say for example, अगर 2 lakh रुपए की money recovery matter है, obviously for that you'll not be going to arbitration because that would be way too expensive, because the arbitrator की fee will exceed that amount. So for that you will be giving up the court fee, which will be substantially very less, and you'll be getting your 2 lakh rupees after a long period of time. But let's say, for example, you'll have to get 50 or 60 crores from the other party. Then if you'll get that 50 to 60 crores after, let's say, for example, 10 to 12 years, then what's the point of getting that amount of rupees after so long, right? So basically, you've just graded the disputes. We cannot see this as an escape for the courts to escape.
Hello.
Yes, sir.
This is Nagraj here. See,
Yes, sir.
there are certain political agreements between the parties.
Yes, sir.
They broke themselves. Otherwise, either party broke themselves. This kind of agreement made between the parties. At the time, can either party can go to the court for the appointment of arbitrator, please? Is it possible? Arbitrator can give award for this?
I'm extremely sorry, sir, but your voice wasn't very clear. Can you please repeat whatever?
No, I mean to say there are political agreements.
There's an agreement, yes.
And either party will break the political agreements among themselves. At that time, injured party can go to the court to appoint a sole arbitrator to settle the matter while giving an award, please. Is it possible according to this ADR?
Indeed, sir. So basically, if there's an agreement between the parties that okay, there shall be a sole arbitrator, and the other party does not agree that okay, we do not want this person to be the arbitrator for this dispute. So in that case, the parties or any of the party who has sent the notice. So there's a basic requirement of sending a notice for the purpose of initiation of the arbitration. So if the other party is not willing to get that arbitration on that arbitrator on the table, the parties can or the aggrieved party, they can approach the court for the appointment of the arbitrator under the section 11 of the Arbitration Act, sir.
You mean to say the political agreements also can be settled by the arbitrator according to section 11 of the Act?
Sir, political agreements, I could not understand that. What could be the political agreements that you are talking about, sir?
No, any political agreement. Nowadays, this is happening everywhere. Nowadays, the parties are breaking by other parties. There is a dispute among the parties only. So that is why one party will be divided two parties. Again, there is a lot of gimmicks as going on among the public. Because of this, at that time, the agreed party can go to the court to appoint a sole arbitrator to settle this issue while giving awards.
Sir, as far as I know that the political, if there's a political agreement, as you say such, if there's an agreement, let's understand it in simple terms. If there's an agreement between the parties, we know that they can approach the court for the purpose of getting an arbitrator appointed. So I believe if there's an agreement, the parties can approach the court for the appointment of arbitrator, sir.
Okay, thank you, sir. Thank you very much.
Okay, sir. I hope, Karthik, I have to an extent answered your question. And sir, I hope that I've addressed your question as well. If there's anything that anyone wants to add up to our discussion, please feel free to add up.
Nothing, just Arpit, I was wondering that I was a part of this arbitration of NHAI. And as you said, these arbitrations are being held in hotels and most of the luxury places. The same arbitration was held in Taj.
That happens.
So basically, they were shifting from a formal conversation to an informal conversation. Anyway, they can't make it formal.
Yes,
formalization that happens in court.
Yes. I've seen in some of the arbitrations that I have set, few of my seniors have actually said shairis during the hearings of the arbitration. So that happens, and it's a very informal process. And sometimes they come in polo shirts and something like that. So it's an informal process. So basically, if your dispute is as such that you can afford to go for the arbitration, so people tend to go for arbitration for that thing. So what you can understand in simple terms, it's written nowhere, but practically if you see things, that there's a grade of disputes which there has been gradation of disputes, so for which people tend to go for arbitration or they tend to go for the traditional litigation. So this is what the change has happened after the arbitration practice has taken up the vogue in our country, right? Okay.
Got it. Thanks.
Okay. Okay, so moving forward, since we saw till the process the arbitrator is appointed, let us see what are the powers and duties of the arbitrator. So basically, if the parties are not able to reach upon an agreement with regards to certain things like let's say for example the language in which the proceedings are to be conducted, the what shall be the place of arbitration, or what are the procedures that we, apart from what the basic the law mandates, what are certain things that are to be followed. So for that reason, the arbitration tribunal or the arbitrator has the authority of deciding those things. And apart from that, the arbitrator has the power to give out certain interim reliefs, right? So these are some of the powers of the arbitrator. Apart from that, uh, uh, generally we know that arbitrators have to disclose whatever their relationship with the parties. If I'm not wrong, the part of relationship is given in the seventh schedule of the arbitration and the conciliation act, and its disclosure requirement is given in the section 12 of arbitration act. Okay, so this is basically the role, powers, and the impartiality factor that is there with regards to the arbitrators. So I hope I've covered substantially with regards to whatever that I could tell you guys about the arbitrators. So if there's anything, please feel free to add up, or else we'll be moving forward with the arbitration process, because this part only will take some of our time, because we'll have a bird's eye view with regards to how the arbitration process works in India, right? Because since it's a very informal process, but there's certain things which law mandates. Okay, okay, ये चीजें होनी है. So we'll be looking at that. What?
Excuse me,
How?
sir.
Yes, please, please,
Sir, I basically have two questions. May I proceed?
please, 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 please.
Sir, my first question is that you just told that if we are not satisfied by the arbitration award, then we can approach the judiciary for enforcement or for challenging it. And my
Yes.
other question is that then, sir, if we can challenge, then again the process is being lengthy, extended, then how it helps in speedy resolution? And sir, my other question is that in arbitration or in mediation and anything like of sort, sir, what is the time limit under which an arbitrator or the judge has to pass an award? Is there any
Okay.
sort of time limit? Thank you.
Yes, yes, yes. I'll address both of your questions. So, if I got your questions correctly, the first question of you is that since if the parties are not satisfied with the arbitral award, they will approach the judiciary anyways. Then how it is an expeditious process? Coming to that question, let us understand that in a courtroom process or in a civil dispute, what exactly takes time, because जज को जजमेंट लिखने के लिए सिर्फ 45 डेज रहते हैं, एंड जजमेंट लिखना आसान होता है, बट व्हाट part actually takes time is the part of getting all those things on records, and the process of collecting evidence, and the process of recording statements, having examinations and the cross examinations of the parties. That part takes time, right? So whenever an arbitral award is challenged, it's not the procedural things that are looked into by the court. Let's say for example, if you are you know uh, if you are putting up an application of section 34 to set aside an arbitral award, so in the section 34 itself, there are limited grounds that are given on which the arbitral award will be challenged. So let's say, for example, uh, the award was against the public policy of India, or the award, I'll list down the grounds for you. If it conflicts with the morality or justice, or it if the subject matter was not arbitrable, or the award was induced by fraud or coercion or something like that. So these are certain grounds on which the arbitral award will be challenged. So if you'll see the traditional litigation, in that what happens in appeal, if you'll appeal to the high court, there are only the questions of law which the high court will look into. The high court will not again conduct your examination, re-examination, or the high court will not collect evidence freshly in the appellate stage, right? So in the same way, if you are applying for the setting aside of an arbitral award, there is a time limit. If I'm not wrong, it's 90 days or something like that, within which the whole proceedings are to be completed. So the court, while setting aside an award, will never go into the procedural part of the things. Like, it will not look into whether the examination, cross examination, or it will not freshly collect the evidence. It's just the limited grounds on which the award was challenged, and whether the award stays on is liable to be enforced on those grounds. That is the only thing that the court will look into. So it's not the new process. Fresh process of arbitration will not start on the stage of setting aside, right? So that is how it's not something that will take a lot of your time. It's a simple question that the court will determine. In that way, we can say that it's an expeditious process. And addressing your second question, what was it? That is there any timeline for completing the arbitration in a timely manner? So yes, there's a timeline. So if I'm not wrong, if I recall correctly, it's uh, uh, from the statements of claims and defenses have to be filed within a period of 6 months, and after that there's a period of 12 months, which within which the whole arbitration proceedings are to be completed. I think it's section 29A wherein all of these things are given. Yes, it's 29A. So there are strict timelines, and additionally there are incentives given to the arbitrators if the arbitral proceedings are completed before time. So per month के हिसाब से उनको, let's say for example 2 महीने पहले आपने arbitration yes 12 months or 1 year. So अगर आपने 2 महीने पहले arbitration proceedings complete कर ली, 3 महीने पहले arbitration proceedings complete कर ली, so उस हिसाब से उनको incentives मिलते हैं. So for that incentives as well, the arbitration proceedings tend to get completed on or before time. Sometimes they do extend as well, but yes, there are timelines that are there within which you'll have to complete the whole process, right? So for more detail with regards to this, you can look into section 29A of the Arbitration Act. Okay.
So then we can't say that in order to meet the deadline, the arbitrators don't usually look into the whole issue, don't go into every detail, and just miss out some points. We can say then how can it is? So, sir, it's not fully.
So basically, if you'll see the period of 12 months or 1 year, it's a very long period if the arbitration proceedings are conducted from day-to-day basis, or if there's a gap of very minimal days, because accordingly you'll plan things out, because both the parties are in a hurry to get their disputes resolved. That is why they have approached the arbitrator for that, because both the parties are willing to get their dispute resolved early. So anyways, when both the parties are willing, the dispute will be resolved in a timely manner. What happens in a traditional litigation is that you'll see that the other party is generally not willing. So what they do is that they take adjournments. They take, because if you'll see the respondent in a traditional litigation, the respondent does not have to pay the court fees. So they tend to take adjournments or delay the proceedings. Civil cases, you might have heard that we'll have to extend the litigation to pester the other party, right? But in the arbitration, if you'll see, the arbitrator's fees is divided between both the parties. So both the parties are paying the arbitrator. So when they are paying the arbitrator for getting their dispute resolved, then when the arbitrator and both the parties, all three of them, are willing to get their dispute resolved early, then there is no point that the dispute might not be getting resolved in the time frame. And a period of 12 months to 1 year is I think more than sufficient to address however the complex the issue is, right? I hope I've answered your query. Okay, Jia, thanks. Okay, so moving forward, we'll see how the arbitration process commences. So basically, I'll be telling you pointers that how things move forward. So these are these stages of arbitration proceedings. So first of all, how does the arbitration proceeding commences? So arbitration proceeding commences when the other party uh, receives the request of initiating the arbitration process, and when they actually agree, okay, let's when they received it and they acknowledged it, okay, that uh, let's start the arbitration process. So the receipt of the letter of request of the arbitration is the point of commencement of the arbitration proceedings, right? And apart from that, if I'm not wrong, under section 9 clause 4, if there's any interim remedy that is sought from the court, in that case the arbitration must begin within 90 days from the date of order of the court with regards to the interim relief, right? So this is the date of commencement of the arbitration, and this is the period within which the arbitration has to commence. Okay, after that, how to file uh, a request for the commencement of arbitration. So basically, as we just addressed, that it begins with the notice of formal invitation for arbitration, wherein the notice includes the names and address and a brief. The arbitration notice, if you'll see, it's not very similar to the traditional legal notice that we send, because arbitration notice actually includes the brief overview of your whole uh, dispute, because that is something which, because if you'll see traditional litigation, the legal notice is not the point of start of your litigation. It's just a thing that you do, because sending a legal notice is not a mandate, or it's not a mandatory requirement, but it tends to be a requirement in the arbitration to send an arbitration notice, because that is the point of commencement of the arbitration proceedings, right? So it includes a brief overview of the whole dispute. After that, uh, the third stage being that the appointment of arbitrator, as we just saw in the previous slides, that how the arbitrators are appointed, the same process under the section 11. If the parties aren't able to get the sole arbitrator appointed, they'll approach the high court if it is a domestic arbitration for the appointment of the sole arbitrator, and if it is a international arbitration, they'll be approaching the Supreme Court. So after that, the uh, okay yes, so after that the arbitration commences after the arbitrators are appointed, and as we can recall, that we must remember that arbitrators shall always be in odd number. After that, the question of the language, seat, and applicable law comes into being. If yes, this point of language, seat, and applicable law, it's the uh, parties who decide what shall be the language of the arbitration, and if they aren't able to decide, the arbitration tribunal decides thereafter, right? But with regards to the seat and applicable law, there's a very in-depth research that can be conducted on this topic, that what is the seat and what is the venue of arbitration. So basically, since we are short of time, to give you a brief overview with regards to the difference between the seat and venue of arbitration, I'll give you an example that, let's say for example, uh, the parties have agreed to keep their seat of arbitration to be of Indore, right? So the seat of the arbitration will be Indore. So what do we mean by seat? Is that the substantive and the laws for the purpose of interim measures or for the purpose of enforcement of award, the substantive and procedural laws will be applicable of the state of Madhya Pradesh, but the parties are free to decide the venue of arbitration. So let's say, for example, if the parties have decided for a Indore seated arbitration, they can conduct their proceedings in Delhi, Mumbai, Kolkata, or any place in India, right? Because seat is basically a question of determination of applicable laws, and venue is a place wherein the parties actually sit and conduct their arbitration. So this is the difference between seat and venue. Yes, there are a lot of judgments, there are a lot of precedents on this point, which we will be covering in our further classes, the full courses that we are going to roll out after this. But for the time being, just understand that the concept of seat is with regards to the legal requirements or the applicable laws, and venue is the physical place wherein the parties sit for the arbitration, right? After that, there are some pre-hearing procedures, like we have seen some of the pre-hearing procedures before, like the notice of arbitration, appointment of arbitrations. Then there are preliminary hearings with regards to the deciding of timelines within which the things are to be completed. Let's say, for example, the parties decide that before this and this date we'll file the statement of claims, defenses, and we'll complete this part on this time. So these are preliminary hearings that happens. And sometimes there are exchange of informations. Let's say, for example, there are documents that is required to be exchanged. Remember that this is not the evidence that is given, it's just a mere exchange of documents. Since this is a very informal process, the parties can decide to have this stage or they can do away with it, right? Then there's a process of oral hearing, which is also discretionary, but if the parties request, then the arbitrator has to conduct the oral hearings as well. So these pre-hearing procedures are voluntary in nature, and they can differentiate from arbitration to arbitration, right? Because it's the parties who will be deciding the procedure with regards to this. And apart from that, one of the pre-hearing procedures can be the interim measures, because before the actual arbitration begins, there are certain interim measures that can be taken either before the formation of arbitration tribunal or after the formation of arbitration tribunal. So if interim measures are to be taken before the formation of arbitration tribunal under the section 11 of Arbitration and Conciliation Act, you will have to approach the local courts, the district court for that. And if the interim measures has to be taken after the formation of arbitration tribunal, you can approach the arbitration tribunal under section 17 of the Arbitration and Conciliation Act, right? Anything, I think if anyone wants to ask anything with regards to whatever that we have covered till now, till pre-hearing procedures, if there's anything anyone wants to add or anyone wants to ask, please go ahead, guys. Okay, so if there's nothing, to sum up, what pre-hearing procedures might include is the notice of arbitration, appointment, preliminary hearings, oral hearings, exchange of informations, or the interim measures, right? So this was our pre-hearing procedures. So we've reached till the point of these procedures. So what happens after that? So after that, the arbitration formally begins with the filing of statement of claims. So basically, statement of claims is a document which is filed by the claimant, as to which actually describes that, okay, this is the nature of disputes, this is the relevant facts and evidence and everything. Basically, in the statement of claims, everything is included, because if you'll see in the traditional litigations, in the pleadings that you file uh, in the court, the suit that you file, the pleadings includes facts only, but in the statement of claims you include everything, right? Facts, laws, evidence. It's your choice that whatever that you want to include in your statement of claims. Similarly, things goes for the statement of defense as well, wherein the points are rebutted of the statements of claims, and the questions with regards to objections of jurisdiction. So this is also one of the points, that if, let's say for example, the respondent with regards to certain matters wish to challenge the jurisdiction of the tribunal, uh, they can do so till this stage, because after the statement of defense is filed, they cannot challenge the jurisdiction of arbitration tribunal, right? So this is the stage till which the jurisdiction of arbitration tribunal can be challenged. So this is how the statement of claims and defenses are filed, and these are typically filed within a specific time frame, such as 6 months period from the date of appointment of the arbitrator, which is given in section 23 subclause 4 of the Arbitration and Conciliation Act. You may look at it, because there's a time period within which the things are to be done, and under section 23 clause 4 it is given that the statements and claims, this whole part has to be completed within a period of 6 months. Okay. After that, there's this stage of discovery and exchange of evidences. So this is the formal uh, place wherein you put up all the evidences. Okay. You know all the informations that you wish to uh, put up with regards to support of your claims and your defense. So this is the stage wherein you do all of those things. After that, there is the hearing procedure, wherein the parties give their opening statements, they present their evidences. Then there's people tend to uh, think that there are no examination and cross examinations in arbitration, because when I started out, I was also not known to the practice that, okay, if you've seen the examination and cross examination in the district courts, there are sort of similar examinations and cross examinations, if the parties agree. They happen in the arbitration proceedings as well, right? So there can be evidence presentation, the examinations and the cross examinations. Then there will be the objections and the rulings. And once the statements of claims and the defense is filed, there can be rejoinders as well. So let's say, for example, if I filed my statement of claims, the defense or the respondent filed their statement of defense, then I can also file the rejoinders. So there are rejoinders as well, and after that, this discovery and exchanges happens, and all of those things happens. But remember that all these processes are decided by the tribunal itself. Okay, so the tribunal decides कि हमको ये चीज करनी है कि नहीं करनी है. Okay, it's not a mandate, but this is the general procedure that has been followed. And after that, the hearings, there are closing arguments, wherein the if the parties wish, they more often they do it only that they can give their written arguments, because the understand, the statement of claims is different and written arguments are different. So the statement of claims is your one big voluminous documents which has all the information with regards to the disputes and all the documents that you put forward to support your claim. But the written arguments is sort of a concise points of arguments that you wish to bring to the notice of the learned arbitrator. So you might have seen this things in the district court as well, in the civil disputes, जहाँ पे उसको हिंदी पे लिखित तर्क कहा जाता है. So basically it's a sort of handy concise form of your arguments and your contentions in the dispute. So that is filed, and after that, uh, while writing the award, so that the arbitrator will have your point of arguments handy before his eyes, you submit that. So after that, the award, the process of passing an award is followed. So, an arbitration award is somewhat analogous to a court judgment, because the arbitrator has listened to both of your arguments, and after that he will decide ki, okay, this party has to pay so much amount of money to this party, or they have to do something or the other things. So the arbitrator decides. So understand, even though it is a voluntary process that the parties themselves have appointed the arbitrator, and they have conferred the power of powers like a judge on the arbitrator. The parties themselves have conferred that power, but it's the arbitrator's mandate that the parties will have to follow, because the arbitration award is binding on the parties, right? uh, and if you might remember our earlier discussion, in the conciliation, the parties will be binding by the advice of the conciliator only if parties will agree. But there is no question of parties agreement uh, in the case of an arbitration award, because they'll be bound by the award of the arbitrator, right? So basically, arbitration award has to be enforced within 3 months. So if you'll see in a civil dispute, what happens is that you might have read under CPC, under order 21, with regards to the execution of decrees, right? So basically, award is somewhat like a decree. You can say that it has to be enforced, because arbitrator will pass the award, but the award will be executed by the court only, right? So you will be after the question of enforcement of the arbitral award varies from jurisdictions to jurisdictions. Let me make this thing a bit clarified for you. So for the enforcement of arbitration award, you will have to see the laws of that state, because क्या होता है कि हर स्टेट के पेक्यूनियरी jurisdictions अलग अलग होते हैं. So let's say, for example, in Chhattisgarh, what happens is that if there's an arbitration award, we'll have to file it before the commercial court at Raipur for its enforcement, because that court only has the jurisdiction of entertaining disputes above 50 lakhs in Chhattisgarh. So we generally tend to file arbitration award in commercial court, but the process might differ in Delhi or any other state, right? So you will have to look at the law of the place where in the arbitration is seated. Remember our discussion about the seat and venue? So that point comes into being at this stage, that wherever the seat of arbitration was, when you'll take the award for enforcement, you'll have to see the law of that place, and accordingly you will have to find the forum wherein you will be putting up your award for enforcement. सो जैसे आप डिक्री के एग्जीक्यूशन के लिए एक फॉर्म वगैरह फिलअप करके उसको आप कोर्ट पे लगाते हैं ना, वही सेम चीज़ यहाँ पे भी आपको करनी है, right? So the original award along with the copy of arbitration agreement will be presented before the enforcing court, and generally the courts will be moving forward with the enforcement after that. So that is how the enforcement proceedings are to be conducted. And if there's anything, if anyone wants to ask, please go ahead. Now's the time, please. Sorry, has anyone texted anything? Would court check the same. Listen, the court will not go into the procedural part of the things. But if you have, because if you wanted to, if challenge the arbitration award, you had the time of, you know, putting up an application for setting aside the arbitral award. But if the application is for the enforcement of the arbitral award, the court will not go into the other things, right? They will simply enforce it until unless there is a separate application for setting aside an award. Jab tak the court wherein the application for setting aside has not stayed the execution of the arbitral award, the arbitral award will be enforced, right? The court will not check again ki arbitration award was right or not. The enforcement stage is not the place wherein you can challenge the jurisdiction, or you can challenge the certain things with regards to the arbitration. For that, you'll have to fight a separate application under Section 34, or until and unless the court deciding the application of Section 34 stays the execution of the enforcement of the arbitral award, the arbitral award will be enforced until unless it is stayed by the other court or by the application of Section 34, right? I hope that answers your question, Jia.
Excuse me, sir.
Yes, please.
Are there any other acts related to arbitration apart from the Arbitration and Conciliation Act?
In India, there's the Arbitration Conciliation Act only, and internationally there are certain conventions like New York Convention, Unilateral Model Law, which function at the international level, and our Arbitration Conciliation Act is a adaptation of Unilateral Model Law. Okay, but in India we do follow the Arbitration Conciliation Act only.
Okay, sir.
Okay, Mandat. Okay, so moving forward, I think you guys might be growing a bit impatient because I was told that this session has to be of 1 or 1.5 hours, and I've taken almost an hours of yours. So let us move forward, and we'll be quickly covering the rest of the part that is remaining. So, okay, so that is how we reached till the stage of enforcement of arbitration award. So to recall, we must let us see how the process has gone till now. There was notice, there was arbitration agreement, there was then appointment of arbitrator, then there was pre-hearing procedures, which were upon the parties' discretion to decide. Then there was statements of claims and defenses. Then there was rejoinders. Then there was the evidence stage, wherein evidence, examination, cross examinations happened. Then there was closing arguments and written arguments, and after written arguments, after all of these process, looking at all the things, there was the award stage wherein the arbitrator actually had written the award, and after the arbitrator has had passed the award, then there is enforcement stage wherein the award will either be enforced or the other party can put up an application for the setting aside of the arbitral award. And if that application is rejected, then there's the process that is given under Section 37 of the Arbitration Act. To understand it uh, more deeply, you may go through that section as well. Just remember that there is no second appeal of an arbitration award, and it's the single appellate procedure that is given in the whole act, right? Because if you'll see CPC, if I'm not wrong, in section 100 or 101, there's a provision of second appeal, but there's no second appeal in the Arbitration and Conciliation Act, right? You may file the SLP or WP for different matters in the Supreme Court, but there's no second appeal as such. in the Arbitration and Conciliation Act, like that is there in the CPC, right? So this was the bird's eye view of the arbitration process. We've took small things from all the stages. We haven't dived deep down into the topics a lot, but I think I have substantially covered the. I've given you the bird's eye view of the process of the arbitration, right? So let us move forward with the more general things like the advantages and the disadvantages, which we might have gotten an understanding of till now, that the process of arbitration is more speedy, cost effective, and flexible, because it's the parties. Because understand, the process of arbitration is speedy and flexible because the parties are willing to resolve their disputes, right? So that is the reason, that are the some of the advantages, and also that the matter of fact that the arbitration proceedings are not bound by the traditional procedural laws. That is also one of the reasons why they are speedy and cost effective. They are also confidential because you do not want to spill your corporate secrets or other things in public. So for that reason also people tend to prefer arbitration. However, there are also certain disadvantages as well, like high cost and complex cases, because not all arbitrators are judges or the lawyers, because there are in some of the arbitrations you might see the engineers or doctors as as arbitrators due to their technical qualifications. So in complex cases there are skilled arbitrators, and the High Court as well prescribes a list of arbitrators, the recognized arbitrators. So that is also done. So due to that reason, because you are setting up your sort of private court, it is a very costly method of getting your disputes resolved. Also, since the arbitration is a very new uh, new venue of dispute resolution in India. Therefore, there are lack of precedents. So there are certain things you may check out after this session, like the question of doctrine of group of companies. How okay, I was not supposed to, you know. Uh, dive deep down in the topics, but let's just I'll tell you a few things. So you may read about group of companies doctrine. So basically there are certain cases wherein non-signatory to an arbitration agreement can also be made a party to the arbitration. uh, let's say for example there's a subsidiary company who was not a party to the arbitration agreement. uh, it became the party to an agreement due to the group of companies doctrine. So this is one of the point of research that is there. Then there's the point of research of seat and venue of arbitration. There are a few precedent with regards to that as well. Then there is the question of emergency arbitrations in India. So ये questions हैं जिन पे थोड़ा research और थोड़े precedents हैं, but all in all the arbitration landscape in India is still evolving, and there are a lot of questions and gray areas in the process of arbitration in India. So ये चीज है that there is lack of arbitration precedents, and as we discussed, there is limited scope of appeals because there is no second appeal in Arbitration and Conciliation Act, and there can be power imbalances and risk of bias with regards to the fact that sometimes because these are the big corporates who opt for the arbitration procedures, so there can be sometimes power imbalances, and a lot of capital is involved, and a lot of things are there that the stakes are very high. So there is risk of bias and the other things, because what happens in a judicial setting is that if you'll see a judge, his life is so isolated that he's kept away from the society so that he could not be influenced or to give a judgment in favor of a party or not, and there's a lot of scrutiny that is there over a judge, over a traditional high court or a lower judiciary judge. There's a lot of scrutiny over him, but that is not so the case with regards to the arbitrators, right? Because award ho ya decree ho, ek baar jo pass ho gayi, that will not be challenged again on the basis of the substantive or the procedural things, right? Because arbitrator ने जो कह दिया सो कह दिया, but that will not be looked into again at the stage of enforcement. So if there is a bias, because the chances of influencing a arbitrator is more, because there's no scrutiny as such. Jitni scrutiny is upon a traditional judge, so there's a risk of bias, and once if the things get messy in a arbitration proceedings, it is very difficult to resolve after that, because the arbitration award is also having a force like a decree only, right? And the court generally tend to do not go behind the decree or behind the award to see whether the things were done in a right manner or not, because that is essentially very time consuming and it will take a lot of time. But these things do happen, and also there are very limited grounds of challenge or setting aside a arbitral award. So if the arbitrator is biased, or somewhere or other, if he is influenced, then it creates a very difficult problem, because influencing uh, a arbitrator with monetary benefits is somewhat less riskier and more possible. But that is not so the case in traditional litigation, because bribing a judge or influencing him with monetary benefits could be very risky, right? And the judge, being a public servant, would be uh, too uh, too fearful to accept anything from the parties. So there is risk of bias in arbitration as well, right? These are some of the disadvantages. If we see the positives of the arbitration process, we also should be looking at the disadvantages as well, right? So these were some of the disadvantages. After that, there's a difference between arbitration and traditional litigation, which we had uh, I think somewhat uh, covered. Uh, Guys, if there's anything, please, you can ask me right now, or I will be moving forward with a bit of a pace now, because the time is running out for us, and I'll have to finish this session before uh, the stipulated time. If there's anything, please let me know about it. Okay? Do not hesitate to unmute yourself and speak up. I'll be moving forward with the remaining part. Okay, so there is this legal framework of the Arbitration and Conciliation Act, wherein the first part is divided into domestic arbitration, second part is international commercial arbitration, third is conciliation proceedings, and the fourth is the miscellaneous part, because as the name itself suggests, it is the Arbitration and Conciliation Act. So the third part is the conciliation procedures, right? Some of the important provisions of the Arbitration and Conciliation Act are Section 7, which we discussed earlier, that key what is the arbitration agreement. Then there is Section 34 with regards to the setting aside of arbitral award, and what are the grounds for setting aside the arbitral award. And then after the arbitral award is passed, then there is Section 36, which talks about how it is to be enforced, right? How it is to be executed like a decree of court. So these are some of the few key provisions of the Arbitration and Conciliation Act. Then the court interventions after the 2015-2021 amendments have been a bit restricted, because पहले कोर्ट क्या होता थी कि interim measures और the interference in the arbitral proceedings पे काफ़ी ज़्यादा interfere करते थे. But that has changed after the amendments that have been passed by the parliament as of now. Then there are the cases of Balco versus Kaiser, wherein the courts like ye landmark judgments are, but there are a lot of landmark judgments of the arbitration. But I have, for the purpose of giving you some leads as to from where you can begin. I have listed these two judgments. You can surely visit the judgment of Amazon versus Future Group, wherein the Supreme Court had reinforced the enforceability of emergency arbitration awards in India. So kindly look into that as well. So emergency arbitration is, to give you a brief idea about that, is that emergency arbitration is the process wherein before the formation of arbitration tribunal, emergency arbitration was not a part of the Indian legal landscape, but it was generally practiced in other countries like US and Singapore. So before the arbitration tribunal is actually set up, if the parties want relief, they can set up an emergency arbitration tribunal, and that tribunal will give a award. So the question was that in India, what we do is that before the tribunal is formed, we approach the court for interim measures. So is the uh, award of emergency arbitration tribunal in international commercial arbitration, is that enforceable in India, like the interim measures passed by the court under Section 9 of the Arbitration and Conciliation Act? So that question was determined by the court in Amazon versus Future Groups. So kindly give it a read. It's a good judgment, and it will tell you about more about the emergency arbitrations and what are they, right? So this was something to give you leads about how you can proceed with. Then with regards to the international framework, I had told you before that there is New York Convention, which is recognized by around 170 countries. So basically what is the international framework for arbitration is that it provides an uniformity, because currently we just looked at the disputes within the country. Okay, party A is from MP, party B is from Chhattisgarh, then there's no issue with it. But there has to be a uniformity with regards to the fact that if one party is from India and other is from United States, and if you want to enforce a arbitral award between these two parties, which was passed in a arbitration, uh, venued at, let's say for example, London, then how or can it be enforced in India? So for that there are international conventions, and accordingly, so whatever the member countries are, they what they do is that they tend to make their laws within their country uh, to to facilitate the enforcement of the international arbitration. So basically these frameworks are for a more structured enforcement of the international commercial arbitrations, the award of international commercial arbitrations, right? So these are two of the most prominent international frameworks on the arbitration, that is New York Convention, and the second one being the Unilateral Model Law on arbitration. Our Arbitration and Conciliation Act is based on the Unilateral Model Law, right? Okay. Then there are arbitration institutes like International Chamber of Commerce, the Singapore International Arbitration Center, and the London Court of International Arbitration. So these are the prominent arbitration centers. There are a few arbitration centers in India. The Arbitration Center of Hyderabad is very prominent. Then there is, if I'm not wrong, yes, okay, the Mumbai, yes, the Mumbai Arbitration Center, but the Hyderabad International Arbitration System Center is one of very prominent arbitration institutions in our country. So these institutions are basically places wherein you will be getting the because what the arbitration proceedings are somewhat very informal in nature. They are conducted in a very informal manner in certain places, but if you want to give some more structure, and you need some qualified professionals for your own arbitration, and if you are willing to pay for that, you can approach the arbitration centers. Or apart from that, the high courts themselves refer the parties to these arbitration institutions. They for the purpose of getting their disputes resolved. So there are certain rules which these institutions do have, which simplifies the process, and there is the administrative support of the whole institution and the whole setup that is there, and there is the access to skilled panel of arbitrators. So for that reason, there are arbitration institutions. Then there is conciliation, as we had discussed, that the conciliation is more of a voluntary process, wherein the conciliation settlement, or the settlement reached upon the part by the parties, will be binding on them only when they sign the conciliation settlement, right? So that is the difference between the conciliation and the arbitration. So that is all with regards to the conciliation. And if you guys want to uh, you know uh, know more about the conciliation, since due to the paucity of time, I am not able to get a lot deep down into this topic. But there are a lot of things that I wanted to tell you with regards to the. Yes. Anyone wants to say anything? uh, okay. Due to the time restrictions, I'm not able to tell you guys about that. But just understand that the conciliation proceedings are more uh, in the hands of the parties and less in the hands of the conciliators, which is also cost effective and very flexible, right? And it totally depends on the cooperation between the parties. So this is something about the conciliation. If there's anything, guys, with regards to whatever that we have discussed till now, please feel free to ask, or if you want to add up something to our discussion today, please kindly let me know about it.
Excuse me, sir.
Yes, please, Mannat.
What is the difference between conciliation and mediation?
मीडिएशन सी कंसिलिएशन क्या होता है कि the parties themselves appoint conciliators, and they sit down to get their disputes resolved through conciliation. But mediation पे क्या होता है कि there's a formal process that goes on, like if you'll see, for the purpose of initiation of mediation, there's a मध्यस्था विभाग in court, wherein जहाँ से आप एक letter send करते हो, then there's a whole formal process that goes on. Like they are more or less the same thing. Like ज़्यादा difference है नहीं उस पे, but mediation पे ऐसा होता है कि लाइक मीडिएटर भी चीज़ें सजेस्ट करता है, और मीडिएशन पे चीज़ें ना थोड़ी फॉर्मल होती है. बट कंसिलिएशन पे ऐसा होता है कि चीज़ें थोड़ी लाइक फ्लेक्सिबल और व्हाट यू कैन से पार्टी सेंट्रिक होती है. मीडिएशन पे भी सेम प्रोसेस होता है कि आपको सेटलमेंट आप ढूंढते हो, एंड एवरीथिंग इज दैट सॉर्ट ऑफ जैसा आपका कंसिलिएशन पे रहता है. बट मीडिएशन पे क्या होता है कि समटाइम्स कोर्ट जो होता है ना, कोर्ट आपको मीडिएशन के लिए व्हाट यू कैन से रेफर करता है. सो इट इज लाइक what you can say court induced process. You can read more about that in section 89 of CPC with regards to the mediation, right?
Okay,
but
sir.
more or less same thing होती है. but mediation पे कहीं कहीं पे court भी involved होता है. conciliation पे वैसी चीज नहीं है. anything else?
Sir, can we enforce mediation in India?
Enforcement, that totally depends. If the parties agree, if the parties have reached upon a settlement agreement, and they wish to get it enforced, then they can surely approach the court for that. But it's upon the parties if they want to get it enforced or not, right? And mediation पे ऐसा होता है कि mediation is sort of a court induced process. So conciliation पे क्या होता है कि parties can themselves decide that okay, we want to conciliate and we want to get our dispute resolved to conciliation. But mediation पे क्या होता है कि if you'll see, let me give you an example. If you want to file a suit in commercial court in Chhattisgarh, then what happens is that there is a requirement of getting your dispute resolved first through mediation. So mediation here in Chhattisgarh is enforced by the court itself. That agar these other party is not responding to your request of getting your dispute resolved, the court themselves then will entertain the your suit. But it is not the case with regards to the conciliation, right? तो ये चीज आती है. So it's totally upon the parties to like get that settlement, that whatever that they've reached is to get it enforced, right? But इस पे क्या होता है कि मीडिएशन पे कि the court firstly tries कि जरूरी नहीं है कि आपका मीडिएशन से dispute will be resolved, but generally there is a requirement that has to be followed, that the parties have to first try out mediation with regards to the dispute, then only the commercial court will entertain their uh, suit. So it's a procedure that has to be followed. Anything else? Guys, if there's anything, do let me know about it, because if not, then we'll be ending our session. And
Okay,
yes, please.
I'm so sorry to interrupt here, but before ending this session, I would just like to deliver a vote of thanks because I want to take this privilege. I didn't got the chance to introduce you.
Okay.
Okay, so shall
Thank you.
I?
Yes, please.
Okay. So if the only prayers you said in the whole life was thank you, that would suffice. We would like to extend a heartfelt thanks to you for sparing time from your busy schedule and for sharing valuable insights on this topic. We are enlightened by your expression that were full of enthusiasm and valuable knowledge. Further, I would like to thank our audience for attending this webinar. Your presence and support mean to us, and we genuinely appreciate your engagement. A special thanks to whole team whose coordination has led to successful completion of this webinar. So thank you so much everyone for joining us. And thank you so much, sir, for sparing your time and to deliver such a wonderful session.
Thank you so much, Ashi. And guys, you've been amazing set of people. I was very happy to address all of your questions and the information that you guys added up to this fruitful discussion. Thank you so much, guys. With that, I'll sign off.